Hello and welcome to the second part of the personal data protection under the GDPR course, part of the Regulate project. My name is Nicoleta Chierciu. I am an affiliated researcher with the European Center on the Regulation of Robotics and AI here in Pisa, and I am also a private lawyer. I assist technology companies with technology law-related matters, including compliance with the GDPR. In this part of the course, we will go into more details with respect to GDPR compliance, and we will take a look at the lawful fairness and transparency principle under the GDPR. We will take a look at the legal basis provided by the GDPR, such as consent and legitimate interest. We will then see how legitimate interest can be balanced against the rights of data subjects. We will analyze the additional conditions required by the GDPR to process sensitive data. Then we will see how the transparency principle can be complied with, including by taking a narrow and closer look at privacy notices content, and then we will see which are the procedures and the policies an organization should implement in order to be GDPR compliant, and then we will see what an organization should be specifically take into account from a GDPR compliance standpoint once when implementing third-party AI tools, and then when developing such tools. So, as discussed also during the first part, the short part of the course, the first principle under the GDPR is the lawful and the fairness principle, which requires that personal data to be processed only if there is one of the legal bases for such processing as provided by the GDPR. Article 6 under the GDPR provides and regulates 6 legal bases. The first one is consent, which means that the data subject should consent to the processing of their data, and then we will analyze these legal bases, this ground, a bit later. The second one is contract. That is, a controller can process personal data if it is required for the performance of a contract, or if it is required for taking certain steps prior to the entering into the contract at the request of the data subject. For example, you can use this ground for your processing if you process data for the purpose of determining whether a customer is eligible for a discount, for the purpose of signing an agreement, or for the purpose of delivering goods and services. An interesting subject here is whether you can process data based on this ground in order to improve your services or your products, such as your algorithms. For example, if you are a software company providing a software license to your customers, you may be prone to use their personal data, usage data, troubleshooting data to improve the algorithm and to rely on the contract ground. However, it should be noted that this ground can be used only if the processing is strictly necessary for the performance of the contract. And in recent guidelines, the European Data Protection Board has stated that normally this ground cannot be relied upon for the improvement of services because it is considered that the data subject has entered into the contract for the performance of the initial version of the product. Therefore, the new and improved version wouldn't be necessarily required for the performance of that agreement. The third ground for the lawful processing of personal data under the GDPR is the legitimate interest one, which we will also analyze in more detail throughout this course. But it should be noted that it allows for the processing of personal data which is necessary in order to achieve the legitimate interests of the controller, provided these interests are not overridden by the fundamental rights of the data subjects, which can be the case especially when the data subject is a child. And the last three grounds for the processing of personal data are legal obligation, vital interest, and a public task, which means that data can be processed when it is required for the performance of a legal obligation or to protect the vital interests of the data subject or of another person, or in order to comply and perform a public task. Normally, these two latter grounds are not used in commercial settings or by enterprises. Now, there are the lawful bases must comply with certain requirements, and there are some important aspects that should be taken into account. First and foremost, the lawful basis, the appropriate lawful basis should be determined before the data is collected and processed, and it should be accurately disclosed to the data subject. For example, you will not be able to collect data based on consent and simply decide down the road that you may have a legitimate interest in processing data and go ahead with the processing without informing the data subject. Furthermore, it is considered that this later notice may be deemed as an unfair processing practice under the GDPR. Therefore, the best option is to accurately identify the ground of the processing before the data is collected. Then it is important to note that you can rely on more than one ground for the same processing activity. For example, if you are processing data again based on consent and the data subject withdraws the consent, which it has the right to do under the GDPR, as previously mentioned, you would be able to process data based on legitimate interest, provided the data subject has been informed. And then it is important to note that the grounds for processing also impact a data subject's right under the GDPR. For example, if you were to process personal data in order to determine whether a customer is eligible for a voucher, you would want to base that processing on the contract contract ground, even if you have a legitimate interest that you could use as a ground. The reason being that if you prioritize using the ground of legitimate interest, basically the data subject wouldn't be allowed to exercise its right to data portability. And data subjects have these rights only if the processing is based on contract. Therefore, grounds should be, again, appropriately identified, and they should be applied in a manner that allows data subjects to control their data and to exercise their rights under the GDPR. So in the next minutes, 50 minutes or so, we will take a look at consent, at the consent ground, and also at the legitimate purpose ground. And then we will see how these grounds apply with respect to the processing of personal data. Now, consent is one of the most widely cited grounds for the processing of personal data under the GDPR, despite the fact that studies are showing that more than 90% of the data subjects don't even read the consent notices they are required to consent to. However, the GDPR provides for specific rules on how consent should be given. Namely, consent should be a clear affirmative act, and it should be freely given, it should be specific, and it should provide an ambiguous agreement to the processing of personal data. Now, this means that silence or pre-ticked boxes are not allowed. Therefore, consent requires an affirmative opt-in. Also, the GDPR requires consent to be granular, which means that it should be given for each processing activity separately. For example, if you are processing personal data for marketing purposes and also requesting consent for data sharing, the data subject should have the option to consent to only one of these two processing activities. Then consent should be informed, and consent is informed when the transparency principle is being complied with, which means that the data subject is provided with all the relevant information, including the purposes for which the data is being processed. Now, it is also important, in order for consent to be specific, that it is unbundled from other terms and conditions, and it should be provided in a friendly and a clear language, and it should also, for example, consent shouldn't be tied to other conditions, otherwise it will not be deemed as freely given. One example would be a case where the provision of a service is conditioned upon the giving of consent by the data subject. This is the case when an individual will not have access to a website or to a specific content if it doesn't give consent, for example, for let's say advertising purposes or marketing activities. Another important and undesirable practice which affects consent under the GDPR is the use of deceptive dark patterns, which are basically those practices which stir the data subject into unknowingly accepting the processing of its data. This is the case, also the case when the data subject is being confronted with too much information, or when UI and UX features of the product direct the data subject towards accepting the consent notice. And these practices have been found again as not as impacting the freely given characteristic of consent under the GDPR. And these practices are also prohibited by customer laws, not only by the GDPR, and also the Data Services Act is currently prohibiting such practices by online platforms, which is actually where most of these practices are being used. Then, as mentioned, one of the other important grounds under the GDPR for the processing of personal data, and which is widely used in commercial settings, is the legitimate interest ground, which requires and which allows for the processing of personal data, if necessarily, in order to achieve the purposes of legitimate interest of the controller, provided that those interests are not overridden by the fundamental rights and interest of the data subject, which is especially the case when the data subject is a child. This requires companies to, before using this ground, it requires companies to carry out a three-part test in order to see if they can use the legitimate interest ground. First, they should see if they have a legitimate interest. Then they should see if the processing of that data is strictly necessary in order to achieve that objective. That is, if the objective can be obtained through less intrusive ways, then those alternatives should be sought and implemented. And last but not the least, the rights of the data subjects should be balanced. The controller should see if the data subjects' rights are impacted. The controller should limit the risks for harm to the fundamental rights of the data subjects. After this test is being implemented, it should also be documented. It should be included in a legitimate interest impact assessment. Organizations should have this document in place in accordance with the accountability principle, which we tackled during the first part of the course. Legitimate interest is actually an interesting ground, as it sort of alleviates the burden of obtaining and giving consent. Legitimate interest has been used especially for advertisement purposes, including direct marketing purposes, which the GDPR allows. That is, companies have been carrying out direct marketing without obtaining consent from the data subject. And if we look at the legitimate interest ground, we may ask, is it the case that a purely commercial interest is a legitimate one, based on which you can process data without consent or without using another legal basis? Until recently, the answer was yes. However, this year, the Dutch Data Protection Authority has actually stated in a decision that purely commercial interests can no longer be considered legitimate interests, therefore excluding this processing ground. Later on, the European Commission criticized the decision and stated in a letter to the Dutch DPA that this strict interpretation of the legitimate interest ground is not in accordance with the GDPR. Now, in a turn of events, actually today, before this class, I read a press release from the European Court of Justice against Facebook, and that decision states the same as the Dutch DPA decision, that the legitimate interest ground cannot be used for advertising purposes nor for data sharing, for sharing data with third parties. Therefore, until now, as of now, it seems that advertising and data sharing will be possible only based on consent mostly, or based on the performance of a contract. So these two grounds, they are applicable as such for the processing of personal data in general. However, there are certain special categories of personal data for which the GDPR provides additional requirements that should be complied with for the processing to be lawful and fair. This is the case of data that is sensitive to the rights and freedoms of natural persons, such as political beliefs, trade union, employment and social care law, health data, sexual orientation, so on and so forth. The GDPR provides for increased protection for these special categories of data, given that they also present a higher risk with respect to the fundamental rights of natural persons. This higher level of protection is being obtained by the fact that the GDPR provides additional requirements for the processing of sensitive data, such as explicit consent. It also allows for the processing of sensitive data from public sources, or when it is required to protect the vital interests of the data subject. Even, for example, taking into account the explicit consent additional requirement necessary to be complied with when processing data, it is important to note that the controller still needs to find a legal basis for the processing as provided by Article 6 of the GDPR. It means that in order to, for example, process health data, based on contract. That is, if you have a health application and you process the user's data in order to provide them with different health reports for which the users pay a subscription. In this case, you would be basing the processing on the legal basis referring to contract. But this is not sufficient. In order to process health data, you would also need to have explicit consent. Therefore, it is important to keep in mind that both conditions under Article 6 and Article 9 of the GDPR should be complied with when processing this type of data. And now we move on to the last aspect of the first data processing principle of the GDPR, which is the transparency one. Under the transparency principle, the GDPR mandates controllers to inform the users in a clear and plain and understandable language about the processing activities they are carrying. The information and the manner in which the information is being presented is crucial, and it's very important. It should be tailored to the target audience, especially when the data subject is a child. Normally, the transparency principle is being complied with through privacy notices. Unfortunately, no one reads these privacy notices because they are lengthy. However, the GDPR also provides that information with respect to data processing can be provided not only through these lengthy privacy notices, but also in a combination with standardized icons, basically in order to have this information easily visible. But again, this practice of using standardized icons is not yet widely used. The GDPR also provides that privacy notices should have a specific content. There is information explicitly regulated by the GDPR that should be put in these privacy notices. First, the controller should inform the data subjects of the identity and contact details of the controller and data protection officer, if applicable. It should explain to the data subjects which are the legal basis for the processing of personal data. It should, if the processing is based on legitimate interest, it should specifically explain which interests are those. Then it should, the privacy notice should inform the data subject of their rights under the GDPR. And the data subjects have, for example, the right to access, the right to erasure, the right to portability, the right to object to the processing, the right to object to direct marketing, the right to rectification of personal data, the right to lodge a complaint with the supervisory authority, so on and so forth. So all these rights should be explicitly mentioned in the privacy notice. Then the controller should also show which are the recipients or the categories of recipients with whom the controller shares the personal data with. That is, if you're sharing personal data, for example, with your cloud services provider, then you should inform the data subjects in the privacy notices about such sharing. And lastly, you should also let data subjects know if you are using automated decision making. And if you are, data subjects should be informed about the logic involved in making those decisions. Basically, they should be explained how the algorithm is taking the decisions. Privacy notices should be always kept up to date, and data subjects should be informed of any changes you are making to your processing activities. So privacy notices, in fact, they're a living document. So now, after having went through in details on the lawful grounds for the processing of personal data, on how you can achieve lawful and fair processing, and on how the transparency principle can be implemented, and which are the requirements provided for under the GDPR in this respect, we will now tried to look at the key policies and measures an organization should implement in order to be and to get compliant with all its obligations under the GDPR. So these measures actually can be used by organizations as a checklist and as a GDPR compliance framework. So every time, basically, if you want to see if your company is GDPR compliance, you can go through this checklist and see if you need it and if you have it. we will briefly go through what each of these policies and measures represent and what they require. So you will most likely have the privacy policy or the privacy notice, which we just discussed about, basically containing all the information on the data processing. Then you will want to have the consent notice through which you gather the consent from the data subjects. We also discussed about it. Then you may want to have a cookie policy, which is the policy stating what type of cookies you are collecting and on how users can manage those cookies. Then you will want to have a data privacy notice for employees, which is normally a notice attached to employment agreements and which provides how employees' personal data is being processed and may be shared with third parties. Then a company normally will have a data protection policy. This is actually an internal policy, and it outlines how the company complies with the GDPR. So it's an internal document, not a public-facing document, and it shows how the company complies with the privacy by design principle, for example, or the data minimization principle. Then, most likely, organizations should have an information security policy, which shows how your company complies with its security obligations under the GDPR. Including the measures taken for such compliance, such as access control, encryption, incident response planning, so on and so forth. Then, in accordance with the data minimization and storage limitation principle, you should have a data retention policy which shows for how long personal data should be kept and how it should be, how and when it should be safely discarded and deleted. Then the GDPR requires controllers to notify security breaches to data protection authorities. It also requires controllers to notify the data subjects of any security incidents. And in this case, you will want to have a data breach notification procedure, which will outline your compliance, the way in which you comply with these breach notification obligations. And it is really important to have this one because it will help you streamline compliance with these obligations. Then you'd also want to have a data subject access request procedure, which will set forth how you comply with such requests from data subjects, how will you identify the data subjects requesting access to data, which is the time frame required to provide them access to data, so on and so forth. Again, this is very important to have it at hand internally in order to organize your departments and then also the stakeholders which are relevant in processing such requests. If your organization is part of a group of companies, you will most likely want to have an intercompany data transfer agreement, which provides how data is being transferred in the group and which are the obligations for data protection and data processing with respect to each affiliate. Similarly, if you are sharing data with third parties or if third parties are sharing data with you, you will sign a data processing agreement. This is an explicit requirement under the GDPR, and it will outline the obligations of each party involved in the processing, in this co-processing activity. And it will provide for clear guidelines and rules on how each party should process data, on how they should cooperate when, for example, having to deal with data breaches, so on and so forth. Also, your company may want to have a privacy and security vendor assessment form, which basically is a streamlined method for gathering the relevant information from your vendors, which may also be the processors of your data. And you will need to get information from them on what security measures they have been implemented, how they are storing data, how they are processing data. Please know that this verification process is a specific requirement under the GDPR. It should be complied with, and basically this vendor form would simply assist the company in complying with this obligation faster. And then last but not the least, sometimes companies require to have a data protection impact assessment. This is required when the processing activities are likely to result in the high risk to the rights and freedoms of data subjects. This would be the case when you are processing sensitive data or processing data at large scale, such as when, for example, training large language models with huge amounts of data, or when you are doing automated decision making, such as profiling. It is important to, if you have doubts on whether to carry out a data protection impact assessment or not, it is important to still have such an assessment as recommended by the European Data Protection Board. So now to conclude, as I have seen this being relevant with all the private actors that I work with, it's becoming very important to know what GDPR compliance obligations you have when you either use an AI tool or when you develop one. Considering that AI is becoming very widely used. So in the first case, if you are a company and you implement a third-party AI tool and you share your client's data with the AI provider, you should most definitely have the following. So you should sign a data processing agreement with the AI provider for the processing of that data. You should make sure that you have your client's consent for the sharing of that data with the AI provider. Again, also you should maybe do the vendor due diligence we just referenced, and it is important to have one because otherwise, you may find yourselves in a situation where you incur reputational damages or fines, or you lose customer trust. This has been recently the case with generative AI providers. For example, reputable enterprise companies have prohibited their employees to use such tools because based on their due diligence process, they have deemed that the generative AI providers do not provide for sufficient security measures. So in order to avoid losing their customers' trust, they refrain from using such tools. Okay, and these would be the main aspects to take into account. And then if you are developing data-dependent products such as AI products, it is important to have a privacy by design approach in developing that product. That is making sure that you process data in a transparent manner, making sure that the product allows for an efficient exercise of rights by the data subjects, to make sure that you have their informed consent, so on and so forth. Then also you should use data only lawfully based on the ground for which it has been collected. If you are developing an AI tool, most likely you will be processing personal data at large scale, case in which a data protection impact assessment would be most then recommended. And if, considering that, again, we are talking about AI tools, they most likely involve automated decision making, in which case the GDPR requires you to comply with your explainability obligations under the GDPR. That is providing the data subjects with relevant information on the logic involved for the data processing, and if this automated decision making is likely to have significant effects or significantly impact the data subject's rights, such as, for example, when employment, when CVs are being screened for employment by AIs, or when university applications are screened by AI, then the data subjects should have the right to challenge the decision, to express their opinion, and also to request human intervention. So with respect to AI tools, it is better to be aware of these measures and be prepared to implement them. And also, in order to be able to comply with the explainability measures, it also matters to take the GDPR into account as fast as possible and document your processing activities. Make sure that you have on record the parameters involved in the logic, the parameters involved in the data usage, and also how decisions are, showing how decisions are made by the algorithm. This being said, the course aims to provide you with an outline on GDPR compliance, and it aims to give you general knowledge so that you can use it when assisting clients or developing products. However, considering that the GDPR and data protection regulations have many nuances, please do not hesitate to reach out to me, and thank you for your attention.